Hey, officer, I heard if you're doing 49 over the limit and above, you get charged with stunt driving. Is that what that guy did?
Yes, the driver was charged with stunt driving, excessive speed. To be exact, for this driver.
Is there anything we can do to get out of this?
The classic. Officer, how do I get out of this one? Well, let me be straight with you. You're probably not getting out of it easily. Welcome back to another episode of Law Unpacked. I'm Sean DeVries, your Florida lawyer who tells it like it is. And today, we're diving into something that gets a lot of people in trouble. Reckless driving in Florida. Now, we've all seen those movies where the hero jumps in the car, floors it, and zooms through a crowded streets without a care in the world. But let me tell you, what happens in the movies stays in the movies. Out here in the real world, that'll land you in some serious legal hot water. If you ever wondered what happens when you push the pedal to the metal a little too hard in Florida, you're in the right place. We're about to get real legal, real fast. So let's break it down. Here in Florida, reckless driving is a specific criminal offense, and it's a bit more serious than just getting a speeding ticket. Under Florida law, reckless driving is defined as operating a vehicle with willful or wanton disregard for the safety of persons or property. Well, what does that really mean? Well, if you're driving like you're in a Hollywood car chase, zigzagging through lanes, ignoring traffic laws, or speeding excessively, you're heading straight into reckless driving territory. Now, it's important to note that reckless driving doesn't just apply to speeding. It's about your intentions behind the wheel. Even if you're not going 100 miles an hour, but you're driving in a way that shows a blatant disregard for the safety of others, you could still be charged with reckless driving. For example, weaving in and out of traffic during rush hour, tailgating someone aggressively, or even running red lights repeatedly can all be seen as reckless driving.
So what happens with his driver's license in the car? Does he lose it?
The license is suspended for 30 days automatic, and the vehicle is impounded for 14 days.
It's not his car, though. He borrowed it. It's his brother's.
Regardless who the owner is, the vehicle will be impounded for 14 days. It's the law.
It doesn't seem fair.
So, it's not your car. You borrowed it from a friend, or maybe it's rental. Well, hate to break it to you, but that's not going to save you in Florida. Reckless driving penalties follow the driver, not the car. Matter of fact, here's the thing. If you're caught driving recklessly, the car could be impounded, regarding on whose name is on the title. Whether it's your friends, your car, your cousins, or even a rental, the law doesn't discriminate, and that's just the start of your problems. So what happens to your license? Well, if you're convicted of reckless driving, the court has a lot of options at its disposal. For a first offense, you might get hit with fines, or the judge could order you to complete community service. But let's be real. One of the biggest consequences is a potential suspension of your driver's license. Now, let's talk penalties. This is where things go from bad to worse.
What's the penalty for stunt driving?
Fines could be between $2,000 and $10,000, imprisonment possibilities, and 6 demerit points upon conviction.
If you're convicted of reckless driving in Florida, the court can throw a range of penalties your way. For a first offense, you could be looking at up to 90 days in jail. Jail, folks, you're talking about sleeping downtown. It's not just a fine. If this is your second offense, you're looking at up to 6 months behind bars. And that's just for starters. The fines can range from anywhere from $25 to $500, depending on the circumstances. But if you caused property damage or worse, injured someone while driving recklessly, those penalties can skyrocket. You might think that once you paid your fine or done your community service, the situation is behind you. But in reality, reckless driving can haunt you long after you left the courtroom. It affects your insurance rates, and not just by little. Insurance companies consider reckless driving a high-risk behavior, so your premiums are likely to skyrocket. So that $500 fine will tack on hundreds, if not thousands more in insurance costs over the years. Suddenly, a few minutes of thrill-seeking on the road doesn't seem so worth it, does it? Here's something a lot of people overlook. What happens if you're caught driving recklessly with minors in the car? Florida law takes endangering children very seriously. If there are kids in the vehicle while you're driving recklessly, the charges can escalate to include child endangerment. And let me tell you, that comes with a whole new set of penalties. You could be looking at jail time, steep fines, and possibly even involvement from Child Protective Services. So if you're tempted to drive recklessly, think about the other lives you're putting at risk, especially if those lives belong to children in the backseat. So what happens if you've been charged with reckless driving more than once? Florida's not forgiving when it comes to repeat offenses. A second or third reckless driving conviction can lead to much harsher penalties, longer jail times, heftier fines, and more importantly, a longer license suspension. And if you rack up too many of these offenses, you could be labeled a habitual traffic offender, which means your license could be revoked for up to 5 years. Imagine not being able to drive for half a decade. It's a huge blow to your freedom, your job, and your life. Let's take it a step further. What if your reckless driving leads to an accident? This is where things really get messy. If someone gets hurt or their property is damaged, you're going to be held liable. Not just criminally liable, but civilly as well. And here's the kicker. Your insurance might not cover it if they find out you were driving recklessly. That could leave you to pay for everything out of pocket. And trust me, that can be financially devastating. Some of you might be wondering, what's the difference between reckless driving and DUI? Well, while both are serious, DUI specifically involves driving under the influence of alcohol or drugs. However, you can be charged with both DUI and reckless driving if you're caught driving dangerously while intoxicated. And let me tell you, if you get hit with both charges, you're looking at much harsher penalties, including mandatory substance abuse programs, and for sure, you're going to have more jail time. So if you're thinking about speeding home after a few drinks, it's not worth it. Unless you've got a foolproof excuse, like I was conducting a science experiment, there's not a whole lot you can do to make this go away.
Speed kills. Slow down.
Thanks, officer.
But here's the good news. It's not completely hopeless. In some cases, there are defenses that can be made. Maybe the radar gun was faulty, or maybe there were circumstances beyond your control, like an emergency. But let's get real. You're going to need a lawyer who knows their stuff and can fight for you in court. All right, what should you do if you or someone you know is facing a reckless driving charge in Florida? First, don't panic. Yes, the penalties can be severe, but with the right legal representation, there's always hope. The key is to act quickly and take the charges seriously. The best thing you can do is avoid reckless driving in the first place. Don't treat Florida roads like your personal racetrack. But if you do find yourself in a jam, don't hesitate to reach out. We're here to help and fight to get you the best possible outcome. Until next time, I'm Sean DeVries, and this is Law Unpacked.